All right, moving on. The Supreme Court has until 11th December to release the detailed version of the judgment upholding President Uhuru Kenyatta's win in the controversial October 26th repeat presidential poll. Maureen Mwangi now revisits the nagging question of the political connection to the court process and explains some of the key issues in the Supreme Court verdict.
After the Supreme Court upheld the election of President Uhuru Kenyatta and his deputy William Ruto on 30th March 2013, following the first general election under the 2010 Constitution, two members of the inaugural Supreme Court bench, Justice Smokin Wanjala and retired Chief Justice Willy Mutunga, shared some critical lessons on presidential petitions.
In Kenya now, from my view, whichever way you decide on a presidential election petition, you will annoy half of the Kenyan people, and you will really make another half very happy.
Let's, even if you're going to change the, to amend the Constitution, let's have that discussion. Do you want to take political issues that can be very, very, very controversial to the courts?
But fast forward to 4 years later, and the Chief Justice David Maraga chaired 6-judge bench, also comprising Justice Wanjala, is facing this test for the second time in just 2 months. Exciting and disappointing sections of Kenyans in near equal measure. The Monday verdict upholding President Kenyatta's win in the contentious October 26th repeat poll already angering the opposition leader Raila Odinga's camp that abandoned the presidential race 16 days to the ballot.
We are not in any way undermining the authority of the Supreme Court, but we are saying that operating within the confines of the Constitution, we do not find it worthy to associate with ourselves the exercise that has gone on. It's a mockery of our democracy. It rolls back the many gains we have made in the electoral process.
There is no perfect election. There will always be errors in an election, but you cannot invalidate an election unless those errors and discrepancies are of such a nature as to affect the actual outcome. That is the law.
Eagerly awaited in the detailed judgment is an explanation on how the bench validated outcome of an election in which 25 constituencies did not participate over chaos following Odinga's withdrawal from the poll. Odinga's legal experts had banked on Article 138, subsection 2 of the 2010 Constitution that seemingly alluded that a presidential election has to happen in each of the 290 constituencies.
Much appreciated.
But Attorney General Professor Githu Muigai has recommended need for legal experts to keenly scrutinize this verdict, alongside the September 1st judgment and the 2013 decision of the top court, as part of a long-term strategy to review the presidential petition's legal framework to safeguard the bench against political manipulation.
Because quite frankly, the standards that have been used in one or two instances have fallen below international best practices.
Issues that may be now remaining are political questions, which, of course, the people who have interest in those issues might want to justify their actions through the Constitution and the laws that we have. But it is a question that probably the Court of Laws might not resolve.
Even with the presidential petition out of the picture, the political dust kicked off by the contentious repeat presidential poll, it appears, will take time to settle, even as Kenyans await the full version of the judgment. Maureen Mwangi, KTN News, in Nairobi.